and a confident personality. The challenge, the excitement that you experience while mooting cannot be gained in classes. Good morning to one and all present here, myself Dania Roshan, and it gives me a great pleasure to welcome you all to this inaugural ceremony of the National Moot Code Training Workshop 2021. Mooting is like a competition with fun, and the grilling helps in building up great oratory skills that develop confidence in your ability as an advocate. Mooting gives an opportunity to prove your case even if you know that you are wrong. And when you argued in a persuasive way with full of confidence and clarity, you feel like you have won the world. To grace this occasion, we have with us our guest of honor, Justice V.S. Dave sir, who is a pioneer in the field of law. He is a well-known name in the field of law. This name is taken with highest of respect, not only in benches and bars across India, but internationally as well. He is the one who introduced the concept of national law colleges in India, and he is one of the founding members of the first NLU established in Bangalore. He is the founder of many other institutions like Homeopathy University, Association of Retired Supreme Court and High Courts Judges. He started his practice in 1960s, and at present he holds the rare experience of spending more than half a century in the legal community. Honorable Justice V.S. Dave sir has served on various top positions. To name a few, former Judge Rajasthan High Court, former Chairman Rajasthan Law Commission, former Chairman State Consumer Redressal Commission, former Chairman Homeopathy University, former AG Lokyut, Patron and former President Association of Retired Judges of Supreme Court and High Courts of India, President Center of Community Economics and Development Consultant Society. He is a patron, ex-president and chairman of many other institutions. A long list is there of his achievement and contribution to the fraternity, community and society. We welcome you, sir, with our due respects.
Thank you very much.
We have with us Justice Pana Chand sir, who is our president of our Rajasthan School of Law for Women. We welcome you, sir, too. We also have with us our principal, Dr. Vartika Arora, ma'am. Thank you, ma'am, for always guiding us. Ma'am, we also welcome you. Now, I would like to invite Principal Rajasthan School of Law for Women, Dr. Vartika Arora, ma'am, for a formal welcome address.
Good morning to one and all present in this virtual room. I, on behalf of Rajasthan School of Law for Women, welcome our Chief Guest, Justice V.S. Dave sir, retired Judge, Rajasthan High Court. It's an honor to have Honorable Justice Dave sir as our Chief Guest for this inaugural session of 3-day RSLW National Moot Training Workshop. As we all are aware, that mooting plays a very important role in the life of a law student, and I would like to mention here that our guest of today is the one who introduced the concept of National Law School, as Dania already mentioned that. And I must mention here that he is one of the founder member of first NLU established in Bangalore. I welcome you, sir. I would like to welcome our chairman, Sir Justice Pana Chand Jain, retired Judge, Rajasthan High Court, the major force behind our college who always guides us and motivates us. Welcome you, sir. I welcome in absentia, obviously, our torchbearer, our director, Dr. Rashmi Chaturvedi. She had some urgent work. That's why she is not able to join this meet. But she is always there as a mentor, and her experience is very helpful in developing this college. Next in line, I would like to welcome all the resource persons who have joined this session, who are going to guide the students in next 3 days sojourn. So I welcome all of you. I would like to welcome all the participants across the nation who joined us in this 3 days sojourn. All the faculty members of Rajasthan School of Law for Women, all the members of Kanodia Girls College who have joined this program with us. Um, I would like to throw a little light on our journey or journey of this law college. We started this in the year 2018 and it was set up by Kanodia Girls College Trust in Kanodia PG Mahila Mahavidyalaya campus. We conduct orientation program every year, which marks the beginning of a roller coaster ride of 5 years journey of the students. In this orientation program, we conduct various programs to give an insight about the course, rules, regulations, academic, non-academic activities, and others things like research, mooting, etc. And as we all know, in 2020 is the year of pandemic, and to deal with that contingency, we organized online orientation program for the batch of 2020. And this year, since the COVID situation is getting better, we are happy to announce that we are conducting 2021's orientation program in a blended form. And this Moot Court training workshop is a part of our orientation program for session 21-22. And remaining session would be conducted after we are done with this workshop. As we know, Moot Court training is one of the most indispensable training taught in law schools. And I would rather say it's the first step in the world of litigation. Moot court training teaches the students for drafting of memorial, preparation of argumentation, techniques of researching, teamwork, how to face grilling question answer round, etc. Without taking much of your time, I again welcome everyone present in this virtual room. Over to you, ma'am.
Thank you, ma'am. Thank you for your address. Now, next in line, I would like to call the organizing secretary, Mrs. Ritika Gaur, ma'am, for a brief introduction about the workshop.
I, Ritika Gaur, wishing a very good morning to all the dignitaries, Justice C.S. Dave sir, Justice Kanachand sir, our principal ma'am, Dr. Vatika Arora, and all the participants and resource persons. Mooting is not just an art to present a proposition before the bench, but it is an application of that proposition to argue before the bench and opposing counsel for the relief prayed for. For a law student, mooting is one of the important aspects of his professional degree that provide him an opportunity to deal with the de facto state of his field. In present scenario, mooting is a moot and moot court is a trend. It is a dream of almost every law student to be the best mooter. RSLW, in order to provide an opportunity to upcoming lawyers of the nation to learn the mooting skills, is organizing a 3-day virtual national moot court training workshop. The course structure of the workshop is designed to impart the participants overall learning of the moot court. This 3-day workshop comprises 6 sessions to be taken by 5 resource persons. Each day there would be 2 sessions in the following manner. On 21st, we have session 1 and session 2. Session 1 is on the topic moot court and its importance in the career of a law student. The timing for the same will be 10:30 a.m. to 12 p.m. The resource person of the session is Mr. Arkanil Bhavat. Session 2 is on the topic how to make a team for the moot and how to coordinate with the team from 12:30 p.m. to 2 p.m. And the resource person for this session is Ms. Atisha Kumar. On our second day, that is on 22nd of October, we have session 3 and session 4. The timing for the sessions are 10 a.m. to 11:30 a.m. and 12 noon to 1:30 p.m. The sessions are designed to provide comprehensive knowledge about the memorial drafting and formatting and listing the compendium, along with do's and don'ts of the memorial drafting. The session will be conducted by Mr. Akash Gupta. Our last and third day, that is 23rd of October, session 5th and section 6 will be conducted. Session 5th is on the learning skill of argumentation from 10 a.m. to 11:30 a.m. The resource person for this session is Ms. Anubhuti Mishra. Session 6 is on the courtroom mannerism from 12 p.m. to 1:30 p.m. The resource person for the session is Mr. Aditya Bora. The session will be succeeded by our valedictory session from 1:30 p.m. to 2 p.m. These sessions will help law students to understand the importance of public speaking and intricacies of the mooting skills. We, as an organizers of the workshop, is expecting that the workshop will help you in achieving your goals. Thank you.
Thank you so much, ma'am. I'm sure that all of us will be benefited from this workshop. Now, it gives me immense pleasure to invite Justice V.S. Dave sir to kindly enlighten us with his words of wisdom and experience.
Thank you, Daniel Roshan. Uh, Let me first thank Dr. Vartika Arora, Professor Arora, for inviting me. In fact, I am at the age of forgetting. You are all at the age of learning. Therefore, I wanted to be excused. But your patron, chief patron, uh, whom I call Kakaji, uh, his very presence is inspiring for me. And we had a long, long association of more than almost 60 years, 55 to 60 years. Traveled 25 countries together. And with Kanodia College also, I had a very long, long association. Uh, your directors, Rashmi's brothers, three brothers, were known to me. One was my class fellow, and two were very close to my heart. I've seen her as a very young child in my student life, and my daughter has been an alumni of Karnadia College. She is now in Bombay. Therefore, with this institution, I have very long association, and it was very difficult for me to refuse the, uh, invitation. Therefore, I am before you. Uh, Most of you are my third generation, if not fourth at least. And it is said, असल से सूद ज़्यादा प्यारा होता है. So you are more closer to heart than the next generation. But there is a great communication gap these days. Therefore, when we talk of olden days. And the straight answer which comes from my daughter who is a practicing lawyer or my granddaughter who is also a practicing lawyer, they say, आपके जमाने में होता होगा ऐसा, अब नहीं होता. I said, वो जमाने गए. I said, वो जमाने अगर गए तो वो जमाने वापस भी आने चाहिए. If the judiciary has to maintain its dignity and it has to balance between the good and bad in the society, and see as the watchdog or the executive and the legislature and give proper interpretation. And now I must congratulate you that you organized the workshop, because normally I have seen only arranging the moot courts. And when moot courts are arranged, it is just, more of the formalities rather than having the brainstorming sessions. So far as this workshop is concerned, they have a great, great importance, because your mind is not like a reservoir. It has to be a brainstorming, and after brainstorming, you learn the art of recalling things and exchanging the ideas, interacting, exchanging the ideas. Your mind has to be a living fountain and not a reservoir. So, if it has to be a living fountain, then all your feelings must be disciplined and patience restrained. So that whenever you come to the profession of law, you have that mindset as to how to start from day one, because the expected outcome of the workshop is one of them is ideal courtroom behavior. So this is the first. I'll come with my own experience to you. When I started practice, it was just after 7, 8 months. My senior asked me, to go and make a mention another court that he is busy in court number one, and the case may kindly be passed over. So I went to one Mr. Justice Indranath Modi. Then he was a very, very disciplinarian judge, a very prominent lawyer he was before being elevated to the bench. I went to his court, and board then said, "My lord, my senior is busy in court number one, and the case may kindly be passed over." He said, "Go and call him. If it doesn't come within a couple of minutes, I'll dismiss the case." I went and communicated to my senior. I then came again and said, "Sir, he is just coming." He said, "Dismissed." He dismissed the case in default. Just then my senior arrived. He said, "Sir, I got to make a mention before your lordships about the pass over the case. You ought to have accommodated." He said, "There was no mentioning before me." तो मेरे पैर के नीचे से जमीन खिसक गई. And I made a request. I said, "My lord, the case may kindly be adjourned." He said, "Mr. Dutt, you have to pay the price of not teaching the courtroom behavior to your colleague." He said, "What, sir? He said, has he not made proper request?" He said, "Yes." He didn't sought the indulgence of the court. Therefore, when I made a prayer, the first and foremost thing for me was to first seek the indulgence of the court. I ought to have said, "My lord, may I please seek your indulgence?" And when the court said yes, then only I could make a prayer. I could not make a straight off making a prayer. Now, this seeking the indulgence is unknown today. In third row, somebody gets up and says, "साहब वो केस बदल देना," as if को हुक्म चला रहे हैं कि वो केस बदल देना. Now this does not have to be happen. When you go to the court, you have to be properly dressed. You have to be you must when you enter the courtroom, it should appear that some lawyer is entering the courtroom. Neither rushing through nor going lethargically. You have to go and address the court properly after seeking the indulgence of the court. So the court behavior is the first and foremost. Certain experience of my life which I learned was, it was in 1969. I had put in quite practice for quite few years, many years. V.K. Krishna Menon was the former defense minister of India. He was a constitutional lawyer, and he used to sit in Ramamurthy and company. So my client insisted that he should be engaged for arguing in murder appeal. So I went to V.K. Krishna Menon and asked him, asked D.P. Singh, he was one of the partners of Ramamurthy and company, he was member of parliament also. So he introduced me to V.K. Krishna Menon and said, he wants to engage you in a murder case. He said, "Me and murder case are unheard of." Then I said, "Sir, my client is insisting upon it and he doesn't want to engage anybody else except you as a senior advocate." After great persuasion, he said, "I'll not put in a head or here. I'll retain it in my throat and I'll vomit it out, whatever you brief me." So I briefed him about the case. Next day, he called me again. When I went there, I saw a heap of books on criminal law lying in his side. Some in Spanish, some in French, some in English. I was surprised to see that he must have burned midnight oil all through the night, reading all these books. But the continental jurisprudence is totally different than the jurisprudence applicable in this country. तो मेरे मुंह से निकल गया, "Sir, your time has been wasted because this jurisprudence is not in India. Continental jurisprudence is different than Anglo-Saxon jurisprudence. He got annoyed and he said, "Get out from here, get out from here. I want to argue your case." I said, "So what I have done?" On that day, Justice S.C. Agarwal, then a lawyer, he was with me. So he tried to pacify him. He said, "No, I don't like a person who insults the books." So I said, "Sir, I am sorry." Bole ke, when you enter into the profession of law, you have to take it down that reading never goes waste. So he gave me a piece of paper and said, "Write down 100 times, reading never goes waste." And I had to write at the age of 40 years, reading never goes waste 100 times. So this is a profession where you are a student every day, reading never goes waste. It is day in and day out that you have to read. So whenever you prepare a brief, before that you read everything, every word about the law. Because when you draft things, you have to be very, very meticulous about it, because that is another outcome which has to be ensured in this, that the drafting is very, very important. First is behavior and then there is a drafting, pleading. Because every word has its own meaning. Mr. Jain is very, more expert than me in drafting, because he is master of it. Uh, I practiced on criminal law, therefore whatever I'll write, it will be okay. But in civil law and constitutional law and others, you have to be very meticulous. Where the word end will come, where the word or would come, where the word may will come, where is the word shall come from, because there is a long distance to travel between may be true and must be true. So may and must also, shall and will also, or an and also. But so that it has to be very, very meticulous. Now, these days, when I see the affidavits coming along with the drafting of the cases and the others, I see it as in verification, it is never written. What is based on the reading, what is based on the legal advice, what is based on other things. Everything has to be very meticulous so far as this is concerned. So in this profession, when we come, we have to be very, very, very meticulous for everything which comes forward, because the profession of law is a very typical profession where you have to have in mind that if you have to reach the top, then for that you must have a very clear vision, and the vision is the goal to achieve. It should be distinct. There should be strong desire. That you have an ambition to go on the top. Uh, when a very, very prominent lawyer from Allahabad, Tej Bahadur Sapru, he did his BSc and then joined law. When he joined law, his professor asked him, "Why are you going in this profession? It's a very crowded profession." His answer was, as written in his autobiography, is that there is always a room at the top. So if there is always a room at the top, then for reaching the top, you cannot climb the top of ladder with hands in your pockets. You have to hold all the pegs, and then alone you can reach the top of the ladder. Therefore, there you must remember what Shakespeare has said, that ambition has to be made of stuff. It is not a wishful thinking that you can be a very successful lawyer, because if wishes were horses, beggars would have ridden them. Therefore, your roots have to be very, very foundation. And for that, the ethics of the profession and the personal values both have to be blended this is done. Therefore, these moot courts, when they were planned, I was member of the committee when the syllabus was prepared, when the Hidayatullah was our chairman, and there was the legal education committee. Therefore, it was made compulsory that there must be moot courts. In fact, it was also said that there should be mock courts also, because mock courts are far more educating than moot courts. Mock courts are where the trials are being conducted. In America, even in school level, I had seen my granddaughter when she was in the eighth standard. There was a mock court in her school. So my daughter took her to me to her school. One judge Carey was presiding judge. Then when I was introduced, she said a sitting judge of the Indian is also with us, so I'll ask him to sit with me on the dais. So I'll ask to sit on the dais. The eighth class students knew much more about the ballistic law than what I knew after putting in 25 years of practice. They knew how many grooves are there in the barrel of a rifle, how many grooves are there, and what are the spree of shots in an AK-47 rifle. What is the distinction between a pistol and a revolver? What is the distinction between a gun and a rifle? All these things were very well known, and it was so meticulously argued that I was feeling ashamed that our system does not teach it to the students. They are in the eighth class. Why it is so? Because America was a crime infested society. People do not move out after 6 p.m. in that society. The crime rate in India and America is more than 1 into 50. Therefore, there are many criminal lawyers and many criminal systems. Therefore, they teach the students at school level that wow, if you go to the college, you go to there and the situation comes, then you can argue your own case also. Because lawyers are very, very, very costly in that particular country. So it is taught even. So mock courts are very good. Therefore, uh, for being successful, you had to have the dreams. But in words of Kalam Sahab, you should not see the dreams in sleep. You should see them in the day and make them reality. There is a very good book, Jonathan Livingston Seagull. It's a small book of about 25, 26 pages or 27 pages, a booklet. Michael Bosch has written it. It's a symbolic life of a Jonathan. There he said, he who flies the highest sees the farthest. So you must have the highest flight so that you can see the farthest. Your vision has to be that much. But while flying, you must have the perfect body, language, and maintain balance from wing to wing and beak to tail. चोंच से लेके पूंछ तक और विंग से विंग तक जब तक चील नहीं अपना बैलेंस करेगी तब तक वो हवा में नहीं उड़ सकती. उसको अगर हवा में उड़ना है, हाइट लेना है, तो उसको अपना बैलेंस करना पड़ेगा. So in this profession also, you have to keep the balance from morning, head to feet, and you have been fit for accomplishing these tasks. You have therefore devotion, dedication, determination. You must, and for that, you must also know the modesty. Behavior is very important from all, from to the client, to the society, to the court, to the colleagues, and all others. So then alone you can have delicious fruits out of it. Otherwise you cannot. Then you must understand what is the distinction between cooperation and coordination, because these two are also important. So when you are preparing the cases and you are running your office where the cases are to be prepared, because while looking into the case law and looking into the file, you don't not only have to seek the cooperation of your colleagues, but you have also to coordinate with the everything, and you must have, because field you are choosing is not bed of roses. It's a law is ever changing, and law is being ever changing. You are a student throughout the life, because if you are a student throughout the life, you have to also know the what is going in the society, because law is nothing but codified common sense, and common sense can be developed by reading, not reading the law alone, but reading the other things also. Psychology is one of the very important things which the lawyer must remember in the court, because you must understand the psychology of the judge. If the psychology of the judge is not known, then you cannot argue the case properly. You, and then you, for presenting that, you have to work like as Lord Eldon had said, that you have to live like a hermit and work like a horse. So in this institution, you have meticulous preparation of the case is important. Lenin had said miraculous prophecies are fairy tales, but meticulous prophecy is a fact. Because if you are misleading the court, if you are not putting the case properly, and you are jumbling up the things and even misleading or even avoiding certain facts, then your cases can be dismissed. I recall one of the cases as early as 1963, Harinarayan Badridas, which came from Rajasthan to Supreme Court. It was the second appeal decided in the High Court, against which the leave was granted. Sheetal was Attorney General of India. He was engaged by the appellant in that case. He filed the case. But when the local lawyer from Rajasthan who has briefed him, he suppressed some of the facts. And when some of the facts were not mentioned in the memo of the appeal, when the memo of the appeal it was not written, then an objection was raised on the other side, because I was appearing on the other side in High Court. So there, when I went there, I said if these facts would not have been suppressed, possibly the court would not have granted the leave. So the court asked Sitalwar that why these facts have been suppressed. He said, "Sir, I do not know, but leave has not been granted in any of these aspects." And go, no, that doesn't matter. Even if whether they were relevant or not relevant, it's not the question. If the facts are on record, all facts in drafting must have come on record. Who knows who will be the lawyer there? We have all respect for you. You are the senior most lawyer of the Supreme Court, Attorney General. They paid, good words in the judgment for him, but at the same time they revoked the appeal, the leave application. That was the first case in Supreme Court when the leave was revoked. So leave can be revoked if the drafting is not proper. If there is suppression of fact, then that alone would be a ground. So because you know, for that everybody is not equally intelligent and lucky, but none prevents you to be equally honest and dedicated. Nobody prevents you to be meticulous in preparing these things. Therefore, these things are very important. A lawyer cannot afford to park in the comfort zone. He has to develop the habit of work culture. So while preparing the cases in moot court also, you have this, because field of law is very vast, and it distinguishes between good and bad, vices and virtues. So long, and therefore living in the society you have to do it. Then one thing which I am seeing these days is very much that smartphones and these phones, you just, when we argue the case and put a case in arbitration, I ask them something, they immediately open it. Sir, this is the answer. This is the law. I said each case has a different facts. Facts of no two cases are identical. They are different. Unless you know the facts of the case, you cannot argue on the law of that particular case. Law is applicable to the facts of the case. Facts are not applicable to law. I know several cases myself with all respect to their lordships, the Supreme Court. In a couple of cases, I did not follow the Supreme Court cases because I knew that particular facts were not brought to the knowledge of the court. Otherwise, the judgment of the Supreme Court would be different. Just like Nathdwara temple case. In the Nathdwara temple case, they decided a particular aspect of the matter, but it was not brought to their notice that what is the principle of Tan Vittija so far as the Vallabh Sampradaya is concerned. So when this principle was discussed by me, then appeal when they said in that particular case, this aspect was not brought to our notice. Otherwise, the judgment would have been different. Therefore, everything has to be there. So this is one aspect of the matter. Then there are few aspects which have to be remembered, and which I often tell to the students that there are few principles. World is driven by information and knowledge and experience becomes wisdom. As I told you just now that my daughter and granddaughter would not listen to me, I tell them one thing, प्रताप सिंह का एक शेर है, वो मैं अक्सर उनको सुनाता रहता हूँ। और वो शेर ये है कि पुरानी कश्ती को पार लेकर फकत मेरा हुनर गया है। पुरानी कश्ती को पार लेकर फकत मेरा हुनर गया है, नए खिवैये ये न समझे कि नदी का पानी उतर गया। So why I am saying it? Because you have far more intelligence, you have far more knowledge, you have far more information. The whole world is within your palm. You can find out answer to anything in a minute's time. But you lack experience of life. Unless they are blended with experience, you will not be wisdom personified. And unless you are wisdom personified, you will not have a proper attitude. Attitude towards the court, attitude towards the society, attitude towards the lawyers. And it is your attitude alone which is a measure of your altitude. आपकी हाइट कितनी है वो आपके एटीट्यूड पर आपको उस पर करेगा. Then reliability, confidence, respect and understanding is another important aspect of the matter. It is in fact, respect is what we owe and love we must give. Because unless you give love, you cannot command respect. Therefore, one has to understand, but at the same time, because you are a young generation, as I told you, the third generation, I'll certainly tell you that you don't have to be the prisoners of the past. Dr. Radhakrishnan said it by inaugurating the Jodhpur University, that I'll advise the students not to be the prisoners of the past, because you are the pilgrims of the future. And if you are the pilgrims of the future, then you must remember what Daniel Webster has said, that if we work on marble, it will perish. If on brass, it will be effaced. If you rear temples, churches and mosques, they will crumble into dust with passage of time. But if you work upon immortal minds and imbue with the principles, with the just fear of God and love for our fellow men, then you engrave on the tablets something which brightens till eternity. The words of Mahavir, words of Buddha, words of Gandhi, words of Jesus Christ, words of Ram, crushed, everything will not go. They are immortal. They will always remember. And therefore, while in this profession you have come, then you have to have the study with the accuracy, precision, diligence, which they are much more essential than the comprehension of mind, because you have to define split hair look and in identical cases, compare them and act and then plead. Therefore, kindly remember that it has been said for a lawyer that assurance must be his bosom friend, experience his wise counselor, caution your elder brother and hope your guardian. Now, this is all very important. When Swami Vivekananda visited America, he addressed in 1901 in Chicago. But later on, when he came to New York, and a book has been written thereafter on him. The book is titled as The Gift Unopened. And if you read the book, several instances have been given as to how there has to be transformation of the society through law, through lawyers. And it was on his inspiration that Ford Foundation and Rockefeller Foundation were born, and it was said that if Christopher Columbus discovered the soil of America, it was Swami Vivekananda who discovered the soul of America. So, what is important for the students, even at this time, is to read the biographies, autobiographies of all important lawyers, all things, and they should learn about it as to what is the profession of law, how they have come to this, that they were able to write it. The last is because when you join somebody's office, then that becomes your alma mater so far as the profession of law is concerned, and you must learn about it. Therefore, your practice in law would reflect upon what you have learned at your office. Nariman, in his autobiography, which has been published 5, 6 years before, it said, a lawyer is like a horse who is known by the stable to which he belongs. तो आप किस स्टेबल को हो उस पे आप सारे करते हैं. बहुत लंबा सब्जेक्ट है, बहुत लंबा, इस उम्र में बोलने का भी नहीं रहा, बहुत सब, और I don't know whether I could justify it or not, but kindly remember, this is one of the most noble professions. You are entering into a field of law where you can lead the society. This country got liberation from the British imperialism. India was economically innovated, spiritually bankrupt, and politically impoverished. And it was the lawyers and lawyers alone, most of them. You can count on them, anybody from Firoz Shah Mehta's presidentship down to Gandhi, Nehru, Patel, everybody was a lawyer. Dr. Rajendra Prasad, everybody was a lawyer. And all these lawyers have brought it. Now, briefless lawyers are in the parliament, briefless lawyers are in the assembly. Now, they have only passed law through these past books which are being read. They have not read the law, they have not attended the courts, they have not. Therefore, these Moot courts gives an opportunity to learn as to how to be a good citizen, how to be a good lawyer, how to be a good leader, because you are the prospective leaders of society. We have failed this country in last 50 years, but the hope still lies on you that you will rebring it, because that glory has brought 136 criminals in parliament. It is shameful. Now, if 136 out of you would replace them, possibly the country will go high. I thank you very much for giving me opportunity to talk to. With these words, I inaugurate your workshop. Thank you very much.
Thank you, sir. Thank you very much. It was indeed a pleasure and an experience listening to you. I would like to welcome Dr. Diptima Shukla ma'am and Dr. Sarla Sharma ma'am, Vice Principals, Kanoria Girls College. Next, I would request Justice Panachand sir for the presidential address.
Thank you very much. You have just heard Justice V.S. Dave, who is not only an advocate, he remained as one of the most fearless judges, a jurist, and an embodiment of the most robust common sense. After his speech, after his lessons given to the students and to all of us, it is very difficult for me to speak on the subject. But there is a practice in the judiciary that if there are two judges sitting together, making a bench and delivering a judgment, then one of the judges delivers the judgment and the another one simply writes, I agree with my London brother. So therefore, it would be sufficient for me to say that I agree with my London brother. We remain together in a number of ways. We remained together as an advocate, as the judges on the bench, and even today we are together. Uh, I would like to say only few things that there is a saying in the Shastras that Aroha Tamso Jyoti, let the knowledge come from all direction. So that should be our mood. A person who thinks that he knows everything, an advocate or a judge, if he says that he knows everything, then I feel and I say that that is the failure of his career in his life. One should always be a student, just as Dave was very much right. Be a student, be a learner, and you will achieve the target. Moot court, there are so many benefits out of it. You learn so many things. And the speakers in the giving the subject of introduction, they have said all things about the moot court and the workshop. I would like to say only few things that recently Justice Ramna, the Chief Justice of the Supreme Court, said that today we are having a very faulty drafting and it becomes very difficult for us to interpret them because there is no clarity about it. Even the enactments are passed by the parliament without any discussions. Therefore, he said that we feel very difficult in analyzing the subject, in giving the proper meaning to the enactment. Therefore, it is a warning. Why it is so? It is because that because there is no qualification laid down in the constitution or in the representation of people for becoming a member of the parliament or an assembly. This is one of the things which should be taken into consideration and which should be discussed in the parliament. Other thing that the parliament should make a law that legislator must have at least minimum education. How it is should be. We have the constitution. It is one of the most flexible and the rigid and the most wonderful constitution of the world. It has taken into consideration the fundamental duties, fundamental rights. But who reads the fundamental duties? If you read the fundamental duties, then certainly we can have number of solutions out of it. In the school teaching also, in the law classes also, I feel that we should discuss, we should teach the fundamental duties regarding this college. I would like to say that must impart lessons on the fundamental duties. Let us explain to the student what are the fundamental duties. In the law classes also, I feel that the explanation is not given to the students. At least what is the meaning of the fundamental duties? What is fundamental right and what are the directive principles? People say, the students say and teachers are teaching that directive principles are not enforceable. It's a very simple thing. You have to explain to the student what is the meaning of these things. Fundamental rights are nothing but the political rights given by the constitution to the every citizen, the person, the time he born. At the time he wants, he gets the fundamental right to live, and to live a life of dignity. It takes into consideration every aspect of the matter. Be a student, you are a student, you are a citizen of this country. You have a right to seek protection from outsiders, protection from the diseases, healthy atmosphere, environment, good environment, good drinking water, good food. These are the requirements for a dignified person. And other things, the directive principles, they are the duties of the state to be provided to the citizen. They give rise to the economic right and the social right. So what is meant by it? That directive principles are nothing but the political right, and the fundamental rights are nothing but the political rights, and the direct principles are the social and economic right. And therefore, the preamble says that we, the citizens of India, promise to give you three justices: political, social, and economic. Social, economic, and political. It is the system is like this. Why this social has come first? Let us understand. Because that was the requirement of the country at that time. इतना पिछड़ापन था कि जिसकी वजह से ये शब्द को पहले लिखना पड़ा. These are the things and the directive principle you see. You can say Article 37 says that fundamental rights are not enforceable. So the government says, yeah, not enforceable, therefore we not enforce it. It's a pity, really. After 71 years after the coming into force of the constitution, we say that they are not, it is a pity. I say, direct principles are enforceable. See the education. The education, Article 45. Article 45 says, the state shall endeavor to provide free and compulsory education to the children up to the age of 14 years within a period of 10 years from the commencement of the constitution. So this should have been done, carried out. This education up to the 8th class should have been completed by the end of 1960. But unfortunately, our government is going retrogressive, and it has bifurcated this into two parts: Article 21A and Article 45. Now, children up to the age of 6 years have no fundamental right of education. What is the shame? What is this pity? Let us understand it. Let us revolt against it. So there are a number of things which we should learn from the constitution. In Quran, there is a saying, "Hey Khalifa, तेने बहुत न्याय कर लिया, अब तुम वहीं जा जहाँ से आया है." Go back to the bar. Again, there should be a, even for the judges of the Supreme Court, there should be the classes for learning. Because when they joined, their knowledge was different, their condition was different, the society was different, the enactments were different. Today there is a change of scenario. They must know. But this profession, this is a wonderful profession. Justice Dave has very rightly said that in our freedom, we got freedom because we had near about 80% advocates who are fighting for us. They were the advocates. You are to become an advocate of that category. That is our case. Simply you changing the face will do nothing, but facing the change will make everything changed. That should be the principle. Let us face these challenges. The statement given by the Chief Justice of India should be remembered. Our teachers should be not only teach on the basis of their class notes, but the class note changes every year. You change the class notes because you are to read everything. You read the judgment of the Supreme Court. They are confused. You will get confused as a matter of fact. Even the Supreme Court is not clear about the Constitution. That is a surprising thing. I have seen that even today, the High Courts and the Supreme Court is committing the mistake that what is the difference between Article 26 and 27? The teachers teaching their constitution should note the difference and should teach the students. Even today, they are not knowing whether the judgment award given by the tribunal, labor tribunal, will be challenged under Article 27 or 26. There are number of judgment, conflicting judgment. Even on promotion, you see that there are conflict of judgment. Every time the court is making 5 judges bench, 7 judges bench, 9 judges bench, 13 judges bench, but doing nothing. Why there should be this? Let there be clarity. Let there be a time-bound program. We do not know what is meant by the sunset laws. They are like the sunset laws. Our constitution should have been that the moment the period is over, there would be nothing left. Everything will be done in accordance with the sunset laws. I mean to say that our scope is very enlarged. Our teaching should be very oriented. It should be practical. Justice Dave has very rightly said that you should have a mastery over the facts. I will narrate only one case. In year 1953, there was a case in which constitutional points were involved. We engaged. It came from Ramganj Mandi, the cottage stone factory. We engaged a senior counsel from the Supreme Court. He came for argument. In that case, I was a very junior one. I merely commenced my practice in the year 1951. It was the case in 1953. My elder brother, Nathulal Jain, and Vedpal Tyagi. They were the two advocates who were arguing and assisting the senior advocate. There was the judgment of the Bombay High Court on the same subject, which was involved before the court. The senior advocate asked Mr. Vedpal Tyagi, who later on became the Chief Justice of Rajasthan, said, read it. Without uttering a single word, he heard it. Then again he said, only, yes, after lunch we will meet. Then he said, ask my brother to read it. Again he was. The case came up before the district judge. Before the district judge, the counsel for the other side said that, sir, I rely upon this judgment. Our counsel also said that I will be citing only this judgment and no other judgment. He made a distinction. Sir, these are the facts of this case. Had the facts been different, the law would have been different. A precedent is a precedent only on facts. The moment you distinguish, therefore never be defeated by the fact that there is a ruling of the Supreme Court against you. Study it, analyze it, and you will achieve. I've taken much time. I promise that this college, our college, I say, will lead the country. Let us produce good citizens, not only good citizens, but good persons in every respect of life. Not only teach them the law alone, but teach them all sciences, forensic sciences, cyber laws, and other types of laws, all the difficulties to how to face them. That should be our motto. And I promise that we will leave nothing left to be undone. We will provide each and everything to this institution as far as possible. Make the best library. Invite the best persons to teach. Invite the persons, experts, to deliver lectures on the subject. Give them all possible conferences, internal conferences, in the classroom conferences, classroom, etc. You provide them everything, all the tools, provide them the best library and the best teachers. I think I would want to see that this college will be the leading college. I promise that we will provide, the management will provide everything to you. Thank you very much. I again express my thanks to Justice Dave, who gave us the leading. We through the he became the light for us, fountain of light. And we will, sir, we will follow the path which you have indicated. We will follow your footsteps. I may say only one thing more, that as Justice Dave said, read the autobiography. Read his book, which is an autobiography, Justice Dave. It will give you a number of things. If you begin to learn it from the beginning, you will not you will not leave it unread till end. It is a beautifully written. It is the experiences, rich experiences that give that are narrated in the book. Therefore, let us follow his lessons and let us make this college a wonderful college. I hope that this workshop will give good result. It will be a pioneer, and let us do such things as and when it is needed. All the best for you, Vartika, Dr. Vartika, and all other teachers who are engaged. I'm saying that I'm very much impressed by Dr. Vartika. Is in all possibilities because of her that this college has given this nice shape, and it has a beauty, it has a bright future also. My congratulations to all. Let us make this workshop as one of the best workshop ever conducted and provide all facilities to the participants. Thank you very much, participants. Thank you very much, everybody who is engaged in this workshop. Thank you very much.
Thank you so much, sir. It is always a learning experience listening to you. Now, I would like to request the co-organizing secretary, Miss Surbhi Mathur ma'am, for the vote of thanks.
Thank you, Danya. Good morning, everyone. On behalf of Rajasthan School of Law for Women and the entire fraternity of the institution, I first of all extend my most sincere thanks to our chief guest, Honorable Justice V.S. Dave sir, who spared time from his busy schedule and graced the occasion. Your thoughts have enlightened our minds, and we will definitely encourage all young budding lawyers, passionate mooters, and everyone present today to think in that direction. Thank you for sharing your courtroom experiences and beautiful quotes of renowned personalities like Swami Vivekanand and others. I'm immensely thankful to the chairman of the RSLW, Honorable Justice Panachan Jain sir, for giving his valuable time and motivating all of us. Thank you for encouraging with your wise words and telling us about the importance of being a learner and student throughout one's life. Our sincere gratitude goes to the respected director of RSLW, Dr. Rashmi Chaturvedi ma'am, for always encouraging us and standing with us as a pillar of strength. Our special regards to respected principal Dr. Vartika Arora ma'am for her constant guidance. When the clubs were being formed at the time of inception of RSLW, Principal Ma'am established the Moot Court Club, and the prime aim was not only to conducting and participating in moots, but also to inculcate mooting skills in everyone studying here at RSLW by arranging workshops for mooting in future. Finally, that aim is being achieved now through this workshop. Our profound thanks to all the very learned resource persons who will be taking 6 exhaustive sessions for all the participants in next 3 days. Thank you so much for associating with our college. An event like this cannot happen overnight. The preparation started weeks ago with the idea of such a workshop proposed by Ms. Ritika Gaur ma'am, Assistant Professor of RSLW, and also the faculty coordinator of Moot Court Club of our college. Without your great initiative, this event would not have been possible. I also would like to thank all the faculty members for making this workshop a reality. We are fortunate to be backed by a team of proactive and enthusiastic students who volunteered in various arrangements of this workshop. I would also like to thank the people who are working behind the scenes for making technical arrangements. Mr. Pawan sir, Dilip sir, Sanju sir, Jiten ji and Mamta ji. Finally, I would like to thank all the aspiring mooters and participants who joined this workshop. I'm hopeful that the sessions will definitely enhance your confidence and other skills required to become a good mooter. Lastly, thank you to each one of you for joining this inaugural session. I hope you have a great day ahead. Thank you.
Thank you very much, ma'am.
Tanya,
Now, I would like to request. Yes, ma'am.
Tanya, before you proceed further, I just want to mention just two things. So, uh, I would just say, first of all, regarding Dave sir's address, he said that experience, he said so many things about the experience and so many things about the seniority. Yes, without the experienced people, without the senior people, budding lawyers are nothing. They can't do anything. So thank you so much, sir, for your words of wisdom. And second thing, I must mention Panchan sir, who gave me um, who gave me so many things to conduct many events in the future and ensure that management would always be there for any kind of facility. So thank you so much, sir. And one more thank you to Ms. Survi Mathur and to Ms. Dania Roshan. Thank you so much.
Thank you very much, ma'am. Now, I would like to request all of you to turn on your cameras so that we can capture this memory of the event. Thank you all. With this, we come to the end of this inaugural ceremony of the National Moot Court Training Workshop conducted by RSLW. But it's just the start of this 3 day amazing journey. I once again thank all our dignitaries and all our participants for coming here and joining us. Hope to see you soon. Thank you and all the very best.
Thank you very much to everybody.
Thank you.